screenshot. This is historic. This is historic. Good morning, good afternoon to everyone. Let me first thank you for your patience. We've had a little bit of technical difficulty and waiting for some of our speakers to come. We're going to start now. Has recording started? Fine, thank you. Okay, today's side event is Actualizing Reparatory Justice, Reparations for Slavery Crimes through Decolonizing Law. Let me first thank our co-hosts, the Coalizão Negra por Direitos, Ilê Omolu Oxum, Howard Law School, and the Emergent Justice Collective. And it's through their sponsorship that we're able to join you today. Let me take the time first to introduce myself and then to tell you a little bit of our run of schedule and how we hope that this side event will fold out. My name is Patricia Viseur Sellers. I'm the Special Advisor for Slavery Crimes to the Prosecutor at the International Criminal Tribunal. I'm also on the law faculty of the University of Oxford and a visiting fellow at Kellogg College. I'd like to make a couple of opening remarks, but prior to doing that, let me introduce the panelists who are with us in the room. To my extreme right is Wania Sant'Anna, who is a member of the Coalizão Negra por Direitos, and she is representing Ilê Omolu Oxum, the Terreiro community of Rio de Janeiro. Let me also introduce Dulce Pereira. She is joining us online. She is the advisor to the Minister of State of Women of Brazil. And then let me introduce to my left, Melissa Hendrickse. Am I pronouncing that correctly? Thank you. The legal advisor for racial justice and international criminal law at Amnesty International Law. And then finally to my right here is Britta Redwood, who is a visiting assistant professor at Howard University School of Law in Washington, DC in the United States. Prior to our panelists speaking to us directly, I would like to speak from my experience at the International Criminal Court and in particularly at the Office of the Prosecutor. This is quite an exciting and important and a significant moment in international law, but also in terms of racial justice movements. Right now, the Rome Statute, which is the governing constitutional, constitutive statute of the International Criminal Court, is being considered for amendments. In other words, we're looking at different provisions of the Rome Statute that relate to enslavement and slavery crimes, and considering whether that statute should now be repaired, corrected. Sierra Leone has proposed that we should add provisions that concern the slave trade as a crime against humanity, and slavery and the slave trade as war crimes. To amend the Rome Statute is to admit that we need more protection today for contemporary slavery crimes that are occurring and that the International Court has jurisdiction over. So therefore, decolonizing law is reforming and rectifying international law, such as in statutes that govern international judicial mechanisms. But when we decolonize, we must make sure that we take a feminist approach, an anti-racist approach, that we understand historically slavery and that we clearly see and understand contemporary slavery. Not only its theoretical application, but actually its practice. To decriminalize acts of slavery today, in particularly the slave trade, means that we have to have solidarity. Reparatory justice means that we have to ask those who are descendants of slavery crimes, how should we decolonize the law? The law is usually a state-made, a state-induced and enforced body. how does civil society, in particularly civil society that's concerned with racial justice, include itself in this decision to decolonize state-made and state-led law? Well, I have to say that Sierra Leone has been open to participation of civil society, of experts, of academics, and of other states. The law is made for us, the citizens, for us to participate in movements. But it comes with responsibilities. And among the responsibilities is that those of us who descend from historic slavery or colonialism, which had its own forced labor, which really was forms of enslavement, we are asked now to be in solidarity with those who are enslaved today, with the subjects of contemporary slavery. If the Rome Statute is amended to include the slave trade and slavery as war crimes, or the slave trade as crimes against humanity, along with its current status of having included enslavement as a crime against humanity and sexual slavery, the contemporary persons who are enslaved and who are victims will have the right to reparations under the Rome Statute. This right to reparations will become more of a principle that governs contemporary slavery, but also that has a beneficial effect on historic slavery. I'm going to stop my remarks now because we have panelists who will be speaking to these issues, elaborating upon, extending, and making us go a bit deeper into both the past, the present, and hopefully a better future for contemporary slavery and for historical hereditary slavery. Let me first turn to Wania Sant'Anna, who will be talking about the afterlives of slavery and demands for reparatory justice in Brazil. There have been violent police attacks on Afro-Brazilian religious practices and objects. So Wania, I ask you to please take the floor now.
Thank you. Thank you, Patricia. I wanted to thank you. Well, first of all, it's a pleasure to be here. Thank you. Go. Hello. Okay, I want to thank the organizer for this side event in the Dirty Words section of the Humanity Forum of People of Descent, for the opportunity of the Black Coalition for Right to be here as a co-sponsor organization. For the Black Coalition organization and the Ilê Omolu Oxum, addressing issues related to justice and reparation is at the top of our priorities. Considering the fact that Brazil has one of the most serious history of slavery, slave trade, and slave selling, it is in its parts, it's not trivial to represent two organizations that, by principle, defend the right of Black people. And yes, Black Coalition for Rights is proud to have 2,093 members associated for the Black movement in Brazil, and now including Ilê Omolu Oxum. The trading in human lives perpetrated by Brazil for 350 long years of colonial history consistently shameful in the past and in the present. Consistent historical record report that between the 16th and 19th century, Brazilian port would have received approximately 3,006,000 slavery, or something like 4 out of 10 African women, men, and children trafficked to American continents. This figure means the exhaustion of human resources imposed on the African continent for 4 centuries. It is true that the practice of the transatlantic slave trade for the American continent did not reach the entire African territory by kidnapping its people, but the colonialism definitely affect the entire African continent, the entire African territory. That is why at the present day, we need to talk about colonialism and decolonization, or past and absence of justice from a plural perspective requires to us to review various aspects of the colonial system. And in the light of this view, include the debate on reparation. Think about reparation in the light of the violation imposed by the slavery. The slave trade and the slave selling force us to review how we approach colonization until in the early 21st century. But there is something equally profound, and that authors us to be here on this particular panel. The Brazilian history of slavery, slave trade, slave selling is still haunts Black people in Brazil with everyday practice of racism and racial discrimination. This practice forced Black people in Brazil to condition of the greatest social vulnerability in the country. From the economic perspective, social perspective, environment indicator shows that it's a sort of deeply profound and political vulnerability. So we cannot ignore the colonization was able to create an economic and political elite that in the colonized territories, as in the case of South America and in Brazil, use racial discrimination and racism to maintain power over the destiny of the economy, politics, and culture. I was invited to this panel to present a specific case about Brazil, a case of victory, directly involving the practice of African-based religions in the city of Rio de Janeiro. History, resistance, and victory. We should talk about victory sometimes, just to make the, no? What is a victory? I was invited because I'm a Black woman practicing candomblé, a religion of African origin, which, like all the practitioners, has a house of origin, has a Ilê. And my Ilê is Ilê Omolu Oxum. This Ilê is led by a very dear and elder Ialorixá. She has 87 years old. My mother, mãe meninazinha de Oxum. A sua peça, minha mãe. And this mother of mine fought for 30 years for us to obtain this achievement. What achievement? To have it recovered the sacred object that at the beginning of the 20th century were seized as a result of legislation that at that time criminalized the cult of orishas. The sacred entity worship that by trafficked and enslaved Black people in Brazil. The criminalization of Black people after the abolition of slave labor and the persecution of their adherents of African religion, including their religious leaders, affected materialize the practice of racial discrimination and attests how racism and ethnic racial hierarchy in Brazil occurred and still occur in Brazilian society. The Brazilian Penal Code promoted in 1890, that is only 2 years after the abolition of slavery that occurred in 1888, typified, for example, the helling practice recognized by the Black community and also for the white people as a false practice of medicine, quackery, and spiritualism. And it was this racist understanding of underpinned the police action against Afro-Brazilian religious house at that time, including the imprisonment of their leaders and the liturgical object present in this place. In the criminal case brought against the religious leader of that time, liturgical objects would serve as evidence, as a materiality of the religious practice that the criminal code of 1899 pointed as illegal. In the case of Rio de Janeiro, the country's capital, since 1880, the largest slave land import in the Americas during the 19th century, with an immense population of African origin, police persecution was intense, systematic, and present in the moment, in the memory of different generations of Black people and its adherents of Brazilian based religions. When my meninazinha, born in 1937, heard these stories of police and repression from her grandmother, Yadavina, when she was a child. She heard from her grandmother that the police made it as a rule rate the house of the heroes, the house worship, arrest religious leaders and their followers, whether men, women, and confiscate sacred liturgical objects, something absolutely unacceptable and by the faithful religious leader. Mãe meninazinha grew up listening to Yadavina complain about this policy rate. In her denunciation about how unfair and unacceptable it was, these liturgical objects were kept in the possession of the police. And it was for this reason, because of this hearing, this sincere crying of her grandmother and from other people of religion, that Mãe meninazinha never gave up the idea of liberate or sacred. And such the sacred liturgical object from the hands of the police. And for another 30 years, she fought for it, smoothly as a Oxum daughter. Oxum daughter. She conquered it. Since 1930, the sacred objects were kept in the Police Museum of Rio de Janeiro and without any public access. It is true that they have been kept in good condition, but without any public access. However, on September 2021, Mãe meninazinha de Oxum managed to have the sacred object held by the police for almost 1 century removed from the Police Museum and permanently transferred for the Museu da República. a federal government agency also located in the city of Rio de Janeiro. Considering the history of kidnapping the sacred object, this collection has gained a really special name, or our sacred collection. A collection of 518 religious pieces with distinctly liturgical meaning, and this name was given by Meninazinha de Oxum, Mãe Meninazinha de Oxum, or Hero in this case. Furthermore, there are many political and legal details of this case and this victory, and I think that it will be very interesting that most of us to know the details, the legal details that base of struggle. That is very, very interesting. It's most important to mention that the fact that related to this achievement are very well documented with wide participation of religious leaders of the city of Rio de Janeiro, very sharing, supporting for them, and echo dissemination in the media. That was quite important for us. At that moment, the sacred objects under the guard of the Museu da República are being properly catalogued, and more important, the historiographical research to them has a main focus, associating the specific information contained in the judicial inquiry, the information published in the newspaper on the time of the police raids, and the sacred objects taken from the religious house. In other words, the historical research aimed to demonstrate that the confiscated religious object materialized the process of criminalization to which was subject African religion leader, and also people of Black majority who professed the faith of African origin. How important is to bring the resistance experience to this panel? Well, we can, from this different perspective, affirm that our sacred collection is today an example of historical reparation. We can affirm the persistence of Mãe Meninazinha de Oxum is a demonstration of confronting religious racism, and very important, a demonstration of respect to our ancestry and religiosity. We can attest that the Ostracat collection today represents an example of respect for all memory, all past. Mãe Meninazinha did not forget the indignation of her grandmother, Yadavina, and continued to her struggle to that all sacred would be freed. That all sacred would be considered as an orphan manifestation of existence, and that therefore it should be known by all people that is all sacred for everybody. After the right to the memory is an example of confronting racism. Is an example of confronting the associated religion racism, and certainly an example of fighting for reparation in the 21st century. Thanks so much. I broke English. I should have a time in this wonderful place.
It was
Just to practice English.
No, your English was constructed enough that we felt and partook in your victory of reparations of African religious objects, because it was an actual resistance and then persistence to get the objects back from police custody and to have them placed in a museum where we can now interact and enjoy with our philosophical and religious stuff. So
Exactly.
thank you very much for bringing that forward.
Right.
I would like to go next to Sister June Soomer, but I would ask if you could switch seats over here so that the people online would see you from the camera or the back of the. No, I'm sorry.
Yeah.
I'm very sorry. Okay, well then, is she online? Okay, well, then we're gonna move to Dulce Pereira. Excuse me very much. Okay, so Dulce is coming to us from online, so I think we have to turn this way. And Dulce is the advisor to the Minister of State of Women in Brazil, and she'll be speaking to us about reparatory justice for special occupation, coalition building, and feminist movements in Brazil.
I must say it's great honor to be part of this panel. And I wish very much I could be there with you, with my friends and partners in this struggle in Brazil to fight against racism, and with this marvelous activist, efficient, and very important woman that has the courage to deal with the issue of making law indeed a space of justice for the world, and specifically for Afro-descendant people and for Africans. Patricia Sellers, I must thank you. I must say that you have been extremely important in our struggles, and that you are one of the people who really put your finger in history to change the very historical injustices we have been facing throughout our journey on this beautiful planet that we treat in such an unfair way. Well, it's not to, you've given us a very relevant challenge, because decolonizing law means, specifically when you talk about a racist country such as Brazil, it means decolonizing a whole society, and it means breaking the pattern of the culture, social, environmental culture that was built in the history of this nation, but also in the history of humanity. Brazil has inherited this path of producing power by practicing ecocide, genocide, and of taking people away, taking the territories by sending people away from their place, breaking their networks, and also making it not accessible for people to enjoy the wealth that nature offers. Brazil is a country that has inherited the concepts of non-human and non-human created by humanity. And like some other nations, has and still does, has built its structures upon a patriarchal racism, creating a concept of less human. Not because there was some type of compassion or solidarity, thinking or referring to the ethics of being human, but because those who are and still are daily, as my friend sister Wania Sant'Anna said, are still considered uh, in second-class citizens, people who face all different injustices and all different forms of brutality. The issue is that those less human are fundamental for this system, as it creates a mass of servants that from slavery became the people who serve the system as impoverished workers. And obviously, the issue of race and gender in Brazil is still a challenge to be discussed in the space of society, but above all, in the spaces of, even though specifically Black feminism has achieved to include the concepts of transversality, the concepts of sectionality, meaning that we have to think of women according to their history, their background, their territories, their way of living, the oppression that we live in our daily life, and also our enormous capacity of building history and of transforming history. Even though Black feminism has been able to introduce those concepts in the whole, in the academy and also in the political system, dealing with gender and race, and specifically with race, is still seen as a practice of divisionism. But why is it so? It is so because we're still living under the imposition of this concept that some of the less human are definitely those who are supposed to serve. That is the same in the political. So, the Marxist view, even among progressive people, that in most processes still see feminism as dividing the struggles, and definitely the decision and the practice of Black feminism also as, in a very dequalificatory way, as divisionist. Why is that so important when we talk about the issues that have been put here about the main theme of our panel? So important panel, as it was beautifully described by Dr. Patricia Sellers. Decolonizing law demands, as it was said, a anti-racist and feminist approach. However, law, especially in the countries that have been historically colonized, but throughout humanity, is produced by those who control power, by those who have the position, the same position that the colonizers had when they took the territories, when they practiced ecocide, when they practice genocide and as they nowadays practice feminicide. The struggle for power puts us women, Black women, who do believe in the possibility of fair societies, in the possibility of what we call bien vivir, bem viver, good life, is not still recognized as a fair, a just, not even as a needed struggle in societies like Brazil. Therefore, if we think that we, in our case, are dealing with a country with more than 120 million people, where more than 56% of those people are Afro-descendants, are Black people, divided scientifically because the data system is scientific in pretos y pardos, which means Blacks, and the pardos, which is the people who are the morenos, as we would call, or those people who are not so Black as it's seen in Brazil, and where more than 60 million of that population is formed by Black women who are still, by our laws, being excluded from the land, not protected, in the case of all different environmental risks created by the corporations, which are protected by the state, and that many times negotiate their protection with the state, while those women have their children dying because of the contaminants of the disasters or of the strategy of the big companies, even government companies, to take them away from their territory because their territory is considered fundamental for the type of development that has been designed and planned and implemented by those gentlemen, few women, who are the ones who keep this patriarchal, racist structure. And what is very intense and very harmful in this type of society, and especially, I should say, in my beautiful country of amazing people who produce an extraordinary culture, mostly Blacks and indigenous. What is extremely complex is that we have created we maintain this system with a structure that is also fed by hypocrisy, by what was some time ago called the jeitinho brasileiro in a general way, but that moves most of the structures of power. What does it mean? It means that I hit you, but I won't leave any mark. I know how to beat people without leaving marks. Or we create barriers for the change in the social structure, for the rise of Black women, for the spaces of interference of Black women, of women in general, but of Black women and of indigenous women. But those barriers are so subtle that they are not easy to capture, to show them in our statistics. Our IDP system is a farce because it doesn't show at all the reality, for example, of the wealth that people produce, even though being in precarious situations, above all, the wealth that women produce and the wealth that Black women produce, and the constant impossibility of accessing basic rights that extremely vital population produces. I know I have a very short time and I will go to my specific theme, but I could not mention that this basic scenario, which goes beyond most times of the good intention of governments. Because as we know, I always say that, uh, if hell is hell, it is full of men, and definitely not just Black men, but obviously men of good intention. Because behind the good intention, in the case of social structures like ours that are not addressed to in an honest way, intentions do not change the lives of people who face hunger when they live at the quilombos, spaces that produce wealth, that have great capacity of production, and yet that cannot do it due to the condition that is imposed on them either by the corporations or by the lack of public policies that do give those fantastic women the possibility of being very active in a honest process of sustainable development. So many victories have been conquered. To start with, collective victories that come from those individual struggles or struggles of specific groups, such as the organization, the alliance of Black women from different political parties, from different institutions, in one coalition that I know that will be seriously talked about by Wanda Menezes and by some of my sisters there. This being able to go beyond the frontiers that are created, especially in the Black feminist movement, and the constant trial of dividing us, of creating false group interests among us, being able to be together in this time where you have so much division in society, having common goals, producing policy, being very active in advocacy. In Brazil, that is an amazing victory. Another victory is bringing to the political scenario the right to fight against the hate, racial hate, showing society the way racial hate, especially against women, has been a result of the Black feminism in Brazil. And it is the Black feminism in Brazil that more than ever is going everywhere, producing concepts, producing knowledge, producing all sorts of new concepts, and we should say a new epistemology that allows us to identify how the territories are being taken by the perversity of those racist processes we live, but to identify the, the women of those territories, such as quilombos, the religious, all different religious terreiros, those religious spaces, to identify the wealth that those women who are indeed ethno-scientists, as many of them call themselves nowadays, that must be heard, must have their knowledge be recognized, and also their voices being heard when it comes to implementing different public policies, but also to implement different approaches to life, specifically considering the way Black women is the very first victim of technological disasters, of climate and environmental risks. It is in this in those spaces, national and international, the voice of those women is being fundamental to rediscuss the concepts of life. The demand for reparation. Reparation is dequalified in Brazil as revenge. The demand for reparation, the reparation in the political system, the reparation, the demand and the systematization on how reparations should be done, not just in the symbolic way, but in the social economical processes. That is a fantastic contribution, an amazing result of the struggle of Black feminists, of Black feminism that goes far beyond the limits of traditional feminism, because it indeed means policy being made, being heard, being articulated, and producing spaces for the action and for changes. For the Afro-Brazilians, it brings many of the indigenous women with us, not necessarily, we don't have the necessary groupings or organizations together, but definitely the action and the strength and the resilience of Black women have really even given life to our feminism. The main demands of our feminism, the main proposals of the feminism, of Brazilian feminism nowadays, come from the reflection, from the struggle, from the systematization, from the academic production of Black women, and most of them Black feminists. Therefore, one of the main issues in this process, in this anti-colonial process, definitely is collective understanding who we are in the geopolitical process, understanding what are the interests that keep us at the bottom of the social pyramids, and creating alternatives as they have been created. It is amazing in Brazil, and and I must say that I am extremely, I get very emotional when I get into university, even into the university where I teach, and see the autonomy the fight for autonomy, the courage and the ability of defining new strategies to fight against colonialism, and definitely to decolonize our society. It's an amazing generational, um, intergenerational process. It's not an easy one. It's not an easy one. And I shall say that another victory is being able to establish an intergenerational dialogue concerning the possibilities of changing the world, the understanding that many of the northern countries come to Brazil now trying to understand how we survived, trying to understand in what consists scientifically our resilience, and yet anchored in the history that we are recovering, as Wania Sant'Anna just mentioned, the history of our ancestors, but also being committed with building a different future that go far beyond the hypocrisy of our society. Thank you very much for this amazing opportunity.
Dulce, thank you very much. And I think that we should really hold in our heart that reparations is not revenge. It's only the beginning of justice. But thank you for bringing all of those factors together. Right now, I understand that we'll be turning to June Soomer, who has joined us online. Of course, the chair of the Permanent Forum on People of African Descent. And she'll be addressing some of the existing recommendations and vision for reparatory justice in the Permanent Forum on People of African Descent. Ms. Summers, may I give the floor to you?
Thank you, Soomer. I thank you very much for your kind invitation. I have to say that the Permanent Forum, from its first session, has put the issue of reparations on its agenda. And we believe that the Africans in the diaspora must speak to the issues of repair, restitution, and recognition. Part of the challenge that we face is that we have not looked at the specificity of different groups and different regions when it comes to the issue of reparations. So that the issue of reparations for people in Latin America is a little different for people in the Caribbean, and a little different for people in the Americas, in the United States, in fact. And we think that we have a lot more work to do with regard to breaking down the call for reparations in each of these regions, for us to then come back together towards a global reparatory justice accord. We also believe that we have not looked at the specificity of groups enough, so that we have not looked at the issue of reparations for women as a group. We have not looked at the issue of reparations for groups like the Maroons. We have not looked at the issue of reparations for people who worked in mines as opposed to on plantations. So we think that there's still work to be done. We have been guided, and ably so, by the CARICOM 10-point reparations plan. But even then, because of the fact that that reparations plan, and I'm from the Caribbean region, I sit on the St. Lucia Reparations Commission. While that plan has the support of governments in the region, it is not the same for Latin America or the United States, where civil society and other groups have had to fight for reparations in a different way. So we believe that while the CARICOM reparations plan offers us the opportunity to put reparations forward as a global movement, that we still can enhance the movement by looking at these specific areas. And the reason why we want this to be done is that we do not want there to be an undervaluing of the reparations that is due. We in the Caribbean have put forward through the University of the West Indies, so we also have that kind of academic support for the research that is done for the Caribbean. We have engaged at the level of putting together a figure for reparations for the Americas, for transatlantic chattel slavery, as well as colonialism. And that valuation has evolved over the years, but I want to tell you about the latest one that we have been given through the Brattle Report as utilized by the University of the West Indies and the American Society of International Law. And there are some very interesting things there that I think that you would want to note. And these are not necessarily issues raised by the Permanent Forum, but will find their way into the Permanent Forum because people are already asking us for things like valuations, costs, and so on. So the Brattle Report quantifies damages. And these damages come under 5 different heads: loss of life and uncompensated labor, loss of liberty, personal injury, mental pain and anguish, and gender-based violence. And these are the things they say that are quantifiable. There are other things that are not considered that are also considered unquantifiable. But I think that these are things that must go on the reparations agenda nonetheless. And these include intergenerational trauma, because intergenerational trauma is now affecting our children, and we must consider it. The loss of identity, the fact that a lot of us don't know where we're from, we have lost our names. I mean, we have the opportunity to reconnect to these things, but it's a loss of identity and the loss of family. And these things are all very pertinent for me to the issue of reparations for women. So we have a quantification here for the 5 issues that I told you about earlier. And there's it is valued at $107 trillion for the period of enslavement, and $22 trillion US dollars for the post-enslavement period. I still think that there's an undervaluation, and some people are afraid of the big numbers, but I'm not afraid of the big numbers, because they think, well, the colonial the colonists and I have a very difficult time with the concept of post-colonialism, because I think colonialism still exists, especially because I'm from the Caribbean and there's still 17 colonies that do not have self-determination. And even those of us who have independence, I still don't think that we are decolonized. I think that that independence It was one step in our decolonization, but it's not the final step. And so I think that colonialism still exists. And so I think that there's an undervaluation for the post-enslavement period, especially when you see the systematic racism that continues to keep us within a system that keeps us in debt. So I think that that's an undervaluation. But for now, I think that as Judge Patrick Robinson, one of the ICJ judges, said, the value of that report is that it tells the victim states that the reparations to which they're entitled under international law for transatlantic chattel slavery, and that it can be used as a tool and a vital instrument to press for reparations. Because before this report was done, we were still trying to figure out how much, but we see a quantification. I think that is very important to us. I believe that the issue of intergenerational and wealth has not been tackled adequately. And I think that we have to address not just the earnings of the state, but also the earnings of plantation owners, banks, insurance companies, and other entities that profited from the transatlantic slave trade. And all of that is still work in progress. And so I want to remind you that those of us who work on reparations recognize that this is not a job for the weary, that we have to continue to look at reparations and to advocate for it generally. Let me tell you why I think that we have to look at the specificities, and I will end with that because I do have to go back to the forum and start the session. But for me, one of the main issues for looking at specificity, because I'm a woman of African descent, has to do with a quotation in the Brattle Report, which says, given the prevalence of sexual abuse and the near constant threat enslaved women faced in having their sexual autonomy revoked or abused, we believe it is reasonable to assume that 100% of enslaved women over the age of 10 faced sexual abuse. And that report estimates that given the years of enslavement, that 3,339,865 cases of gender-based violence were experienced by enslaved women. You understand that? Over 51 million cases. And if we don't look at the specifics, I think that we will undervalue. And I think that you should call on the Permanent Forum to ensure that all dimensions, all facets of reparations be considered when we are looking at reparatory justice. Thank you very much.
Well, Chair Soomer, I thank you very much. I'm very happy that you've based this on the Brattle Report, which I'm familiar with. And Judge Patrick Robinson, I have to say, is a colleague of mine. I think that we have to take your lead and not be afraid of big numbers, because we have lived through big horrors. We have descended from enormous numbers of torture, of sexual violence, of deprivation of life. So thank you for encouraging us to go big, stay big, and possibly go bigger to finally encapsulate the harm and the transgenerational effect of the harm we still live today. I would now like to turn to my left and ask.
Sorry, I'm so sorry to interrupt, but I really have to leave because I have to start the next session and I have not had lunch. I've been in 2 sessions before this way. That's why I was late. So,
When
but I'm very happy, and we can continue the conversation sometime after the forum.
Thank you for joining us.
Thank you so much.
Okay, now we'll turn to Melissa Hendrickse, who's, as I mentioned before, is a legal advisor for racial justice, international criminal law at Amnesty International. And she'll be looking at a future of racial justice within international criminal law. That's to be followed by a question mark, I understand.
Yeah.
Right, okay. Understanding the need to decolonize international law as a statement. Please, Melissa.
Okay, well, let me start by thanking you, Patty, and the organizers of this side event for the invitation. It's an honor to share the platform and sit beside such brilliant people. I think, I'm going to focus my remarks on the relationship between international law and reparations for slavery, enslavement, the slave trade, and colonialism. I want to give a disclaimer. 7 minutes is quite a short time to try and tackle the ISIM article and opening the question of decolonizing international law, whether that's even possible and what that would leave behind in terms of international law. So I'm going to leave that for another day, and maybe people smarter than me to look at. But I'll focus, specifically on kind of certain colonial vestiges within international law, which continue to make reparation for the historical injustices of slavery, colonialism, slave trade, and all the attendant violences that accompany those processes. These colonial vestiges which make reparation seemingly impossible, or unthinkable, and then ever elusive. And to frame the kind of problem that we face in international law, I'm going to borrow the words of the former special rapporteur on contemporary forms of racism, Wania Chile. And she describes this conundrum as follows. She says, part of the problem then is that international law has not fully been decolonized and remains replete with doctrines that prevent the reparation and remediation of the inequality and injustice entrenched in the colonial era. And so I think I'm going to get to these kind of doctrines, or what I call colonial messages, in a second, but I think it's these specifically that I think people working on reparations, international lawyers, activists, need to radically reconsider, to challenge, and if you like, decolonize. I think an important place to start is kind of the historical complicity of international law in not only legitimizing processes of European imperialism, slavery, colonialism, but also the way that international law actually facilitated and operationalized these processes. It's important to note also that slavery and colonialism weren't kind of aberrations or random acts by bad apples or certain evil European men. It was really a system that was effectuated through international law, through treaties between European powers. And so we need to kind of understand the role that international law has played in that process. And I mean, when we move to the present now, when faced with demands for reparations for slavery and colonialism, the central claim by European states is that these acts, these processes weren't considered either wrongful, weren't prohibited, or weren't crimes under international law at the time. And as such, there's no duty to provide reparation. This kind of brings me to this principle of non-retroactivity in international law, or the intertemporal principle, which basically holds that the lawfulness or wrongfulness of an act in international law must be established on the basis of obligations which existed at the time. And there's a related principle in international law, distinct but similar, which is the principle of legality and this maximum non incremen sine lege, which means an individual can't be criminally prosecuted or punished on the basis of acts that were criminalized by the law at the time. So I mean, this is kind of the quandary we face, is that according to prevailing accounts, slavery and colonialism weren't considered wrongful at the time that they were committed. But what do we do with that, given kind of international law's, really deeply entwined relationship with authorizing and kind of operationalizing these acts? For example, in the case of international criminal law, we see, the moment at which international criminal emerges is really only in response to the Second World War. And as a direct response to the horrors of the Holocaust, but you had obviously the centuries preceding it of kind of violent atrocities committed by European states, European individuals against the rest of the world, the global South, non-European people of color in the name of conquest, colonialism, and empire. But these things weren't legible under international law as crimes. It's only, when kind of comparable atrocities are committed within the borders of Europe or against Europeans that Western states then have to kind of concern themselves with criminalizing these acts. And so I think this relationship between international law and providing legal authority and legitimacy for a history of violence, of racial terror, of imperialism against the rest of the world really needs to be urgently interrogated. It's the idea of non-retroactivity, of legality is the reason why, for example, Germany won't recognize or won't give an unqualified recognition of its systemic extermination of the Nama and Pereira people in Namibia during its colonial reign as genocide. Because, according to the principle of non-retroactivity, of legality, genocide only emerges as a crime in the aftermath of the Second World War. And so it didn't exist at the time that Germany was systematically exterminating the Nama and the Pereira people. And similarly, in the last 2 years, there was a case in the Belgian court where women who were former colonial subjects of the Belgian state in the Great Lakes region of Rwanda, Burundi, and the DRC sought reparations for the kind of colonial harms, the colonial violence that they were subjected to, but were told by the court that these acts are terrible and we're sorry, but they don't qualify as crimes against humanity because at the time that they were committed, this concept didn't exist. And so I think, I'll conclude with some questions, but because I think that this raises a number of questions for us working on reparations. The one is that given this kind of intractable relationship between international law and European imperialism, can it be that we have recourse to this kind of very same legal architecture to then pursue the remediation of harm that they caused? Is it not that we need to then radically reform the system, decolonize it, if you will, and then what does that look like? And maybe that's a question of the audience and fellow panelists. And finally, when we are thinking about what was legal, when it was legal, at what point, which forms of violence are crimes, which are legible as kind of wrongs under international law. I think it's also important to pose a question, by whose standards are we judging that? Because a lot of the time when legal scholars look at kind of the customary status of slavery and colonialism and international law, they're making reference to European law. The laws of nation states is often code for European law. And when you kind of push a bit deeper, you'll find that within Europe itself, much of the time that they practiced slavery was actually outlawed within, the metropole. But that didn't extend beyond the borders of either enslaving or the colonial states. So I think we need to subject that the standard by which we determine legality or illegality also quite critically to look at whose principles, whose standards we are actually enforcing. So I think I pose some questions, rather than give an answers, but I think maybe it's something for the audience to think about it, and I'll end here. Thank you.
Melissa, thank you very much. I would have to say that those are fair questions. I could add to your list of the coloniality of international law, the whole idea of custom and customary, which makes you go back and reinstate what occurred prior, which means you maintain the prejudice of priorness. But I think you also have given hope, because some of that international law might have been regional international law. And I don't think that Amerindian or indigenous peoples in the Americas believed in transnational or transatlantic slavery. And so we have to question even the basis by which we legitimize the prior law. But thank you for the questions and making us think that if we're going to decolonize, we should be thinking about the future to make sure that we're not making a harmful law as we decolonize for people in the future. Now I'd like to turn to our next panelist, who is Britta Redwood, who is a visiting assistant professor at Howard Law School, who will be speaking about reparations awards at the International Criminal Court and the procedural barriers for reparatory justice under international law. Please, Britta.
Thank you so much, Patty. Good afternoon. I'm so pleased to be here in conversation with those on the panel. And I really look forward to a broader conversation with those in the room and online today and also onward. So I'm a US-based scholar of international law, and I'm in conversation with the movement for reparations. And so I want to actually pick back up on what Patricia Sellers mentioned at the beginning of the panel today, criminalizing contemporary forms of slavery within the Rome Statute and the Crimes Against Humanity Treaty, and also in conversation with Melissa's intervention as well. My frame of reference and my point of comparison is transatlantic chattel slavery of the kind that occurred in the United States and in the Caribbean. And I'm sharing this perspective because I suspect that it's one that I have in common with many of you. So in my view, the way that we talk and think about the legacy of transatlantic chattel slavery has been limited and de-radicalized by an overfocus on harms done to enslaved people. Now that sounds controversial. Not that harm shouldn't be a central part of the conversation, but I believe that we can go much further. So transatlantic chattel slavery was a handmaid to capitalism. Its viciousness and the kind of creative brutality that it inspired in those who perpetrated it were not motivated only by racial animus or perverse desire to be cruel for cruelty's sake. It was money. And the way that slavery was practiced and the laws that came to govern it were animated by a desire to wring out every last bit of value from people that could be wrung out. And we see this in the laws of the time. There's a whole period between the 17th century and the 19th century in England in which English courts were really trying to figure out what slavery was legally. In the early days, enslaved people were referred to as servants because England was a semi-feudal society with servants. And it took generations of jurists grappling with the institution of slavery to transform enslaved people from servants, which had some modicum of rights, to slaves, which could be traded, borrowed against, and insured like chattel, like things. And during this same period, by the way, England transitioned from an agrarian feudal society to an early industrial society. Economists have begun to demonstrate this truth, and slavery created the wealth that changed and modernized England's society and economy and improved conditions for English workers and paved the way for the rights-based societies that we see in Europe today. In every slave society, and those that benefited from them, the US, the Caribbean, England, France, I'd also put Belgium in that category too, talking about the kind of slavery that existed in the colonial moment, there was and continues to be enormous wealth that came from slavery and has since flowed into other industries. And the wealth transfer that slavery made possible from blood into gold continues to shape societies around the world today. Okay, so every time I give my students a history lesson like this, the question in the room is, why does this matter? Two reasons. First, slavery continues to exist around the world, as Patricia Sellers was explaining, and it has the same motivating force. It is used as a tool for consolidating power and later or simultaneously for consolidating wealth. It's used as a tool by individuals, but also arguably by multinational corporations who benefit from proximity to conflict and resource exploitation. Second, criminalizing slavery qua slavery within the Rome Statute or the Emergent Crimes Against Humanity Treaty means that the law can finally focus on the perpetrators rather than over-focusing on the harms to the victims, which is a difficult strategy and has failed repeatedly in the US and in France. It means that the law can grapple with
the powers attaching to the right of ownership, which is how slavery is defined in the existing 1927 convention, and what those powers mean for the people who enjoy them. I see this conversation about contemporary slavery as intimately bound up with our historical ideas about slavery. The law, as it stands, as Melissa so wonderfully and depressingly explained, cannot get at the historical crime of transatlantic chattel slavery. The law, as our colleague from Brazil also eloquently explained, is created and monitored and limited and expanded by the powerful and does not overlap with what justice requires. So there are lots of procedural hurdles to getting a legal accounting for slavery, but I think thinking about what total exploitation of people as objects means for both the victims and the perpetrators is at the heart of the political discussion that we'll keep having about slavery in all of our societies. And it's also at the heart of this move to criminalize contemporary forms of slavery. I don't have much time to talk about it here. I want to keep it short, but as the International Criminal Court thinks about reparations for contemporary slavery-related harms, it is in the process of developing a nuanced, detailed, mostly victim-focused reparations jurisprudence that can be used as a model or a framework for thinking about historical slavery. So in conclusion, contemporary slavery as a crime must exist and be treated as a crime because it's both right and necessary, but also because for all of us who exist in the shadow of the legacy of slavery, it opens the door to reckoning with how we address that legacy. It helps us expand our thinking, it helps us innovate, and it helps create a different political reality in which justice is more possible for everyone. Thank you.
Okay, thank you very much. Everyone's presentation was really insightful and leads us to think about the past, but much more about the future and what is possible with the victory. Lily, I hope you'll excuse me if I'd like to go directly to questions. I think we've had a very patient public, both present here in the room and online. So how about if we do that, and if you could tell me what questions might be online. Sir, I see you raising your hand first, please. Would you introduce yourself and then the question and to whom you're asking?
Okay, it's actually to the panel whoever wants to pick it up. My name is retired judge from the UK, representing the Society of Black Lawyers in the UK, but also Band of Africa, based in Nairobi, Kenya. Just a question, is that taking on board, we had a session on litigation on Tuesday, strategic litigation. And I just wanted to ask, where the litigation, where the respondent is not a colonizing country, but is actually a government, for instance, in Tanzania, which is oppressing, displacing 250,000 indigenous people in Masai. And the legislation they're using is colonial, post-colonial legislation. But they're actually acting in concert with people from the UAE, or the Chinese, new colonizers, or newish colonizers, who want to trophy hunt and move huge numbers of indigenous people off their lands. How do we help to litigate that using the lessons we have from Brazil, from the Caribbean, from across the world? How do we engage that struggle on the basis that our elites on the continent are often acting hand in hand with the colonizers?
I open it up to the panelists, and Dulce, if you're online with us.
It strikes me that, you know, in the last generation or so of international law, there's been a push to create another realm of international law, which is not solely state-based, and to increase the thickness of the rights of indigenous peoples. Now that body of law is not as strong as it should be, as it must be, but that's there within the law. So I guess I would be interested in how those frameworks loop into the situation that you're talking about.
Falar, você produz? Se eu falar, você produz? Traduz para mim? Eu vou responder a ele. Aí você traduz? I asked for a friend of mine just to share a little bit, to share what I want to speak to answer your question. But I will ask for a friend of mine to translate it to Portuguese to English. And it's an opportunity to introduce my friend of mine. Diga quem você é.
Good afternoon, my name is Wania. I am from Brazil, specifically from the northeast of Amazon. I am from Belém, Pará. And I am an indigenous and Afro-descendant person. I have my great mother is indigenous and my great father is a Black person, and I am this person. Now we have a researcher that calls it Afro-Indigenous, but we know that it's still being searching. We have Black movements and Indigenous movements dialoguing about it, but that is how I feel more comfortable to talk about my racial identity. I know it's mixed, and it's how I feel more in this fight.
E agora eu vou responder a você. No Brasil, um dos nossos maiores problemas, se não o maior problema, é a terra.
Is territory, is land.
Essa é a base do conflito e da ausência de direito das pessoas indígenas.
This is the base of the conflicts and the rights of indigenous people
E das pessoas negras.
and Black people.
Sendo o maior território colonial das Américas,
Brazil being the most bigger colonial territory of America,
que não tem qualquer paralelo com os Estados Unidos, qualquer,
which doesn't have any parallel with the United States
ou Canadá.
or Canada.
Eu diria que, sem a resolução do problema da terra no Brasil,
I would say that without any resolution with the land problem and territory problem in Brazil,
nós não conseguiremos pensar sequer em alguma coisa relacionada a desafio climático.
we couldn't even think about the great missions.
E para absolutamente confirmar isso, e penso que o problema no Quênia deve ser gravíssimo,
And to confirm it absolutely, and I think the Kenya issue is very,
dada a posição geográfica que ele ocupa,
because it's
quero trazer
their
um
position
dado histórico para você.
and the historical.
A abolição da escravidão no Brasil aconteceu em 1888. Né? Eu disse isso aqui na minha apresentação. E em 1850, nós tivemos a promulgação da Lei de Terras. 1850. 50. Nós temos e é neste momento em que a terra deixa de ser livre para ser cativa. E isso está justamente relacionado ao debate sobre o fim da escravidão.
When the colonization came to Brazil, we have the establishment of this problem with land, and the land is not free anymore.
Atualmente, são os proprietários de terras com o agronegócio que comanda o pensamento político no Brasil e definitivamente a maior ameaça à democracia.
Nowadays, the landowners are the people who led the political thinking in Brazil. This is our most issue. This is the most challenge.
Posso complementar também?
E finally, what we think is the rearrangement of how land have been disappropriated or reappropriated at the 21st century. China is dealing with this quite well. That's the question. It's not a question related only to Brazil, but Brazil playing a very important role on this. And also Africa having been rebuilt on this new perspective of how land and o que tem dentro da terra, what you have on this land, the rich, the wealth, and the power. You know? So I don't know how to deal with it international law. But what is incredible, the question related to the land has a lot to do with international law. It's incredible, you know, including boundaries. Including boundaries. Boundary? Fronteira?
No, fronteira.
Thank you. I just add that one of the things that the Pan-African Lawyers Union was doing in Tanzania is politicizing it by having campaigns which call for a tourism boycott of Tanzania until the laws that are being passed are protected and affect indigenous rights. So I just wanted to share that with you, but thank you very much for your
Thank you
contribution.
very
And
much.
I look forward to you coming maybe to Pereira.
Lily, are there any questions online?
We have one question online by Steve Ramoni. Steve is asking, what are the legal challenges and barriers to implementing reparations? And how can these be addressed from a decolonized legal framework? And relatedly, how can reparations contribute to broader social justice goals, including systemic racism, inequality, and marginalization?
Okay, so I turn to my panelists, or Dulce, if you're still online.
I can perhaps try to answer first, and then Britta, please jump in. I mean, I think, you know, some of the barriers are what I spoke about, you know, in my intervention. You know, the question of temporality, temporal principle, the idea that also, at least from the perspective of punishment, you know, the perpetrators of these harms are no longer with us, so it's difficult to distinguish who they are, and who the victims are in terms of the ancestry. And so I think, you know, when we consider reparations, it needs to be more of a kind of structural approach. It's obviously looking at rectifying past harms, but I think also particularly at dismantling the kind of the legacy of slavery and colonialism, which pervades every single part of kind of the international legal order. So, you know, from international economic architecture, the structure of debt, I mean, even something like the P5 and the Security Council, these are all kind of manifestations of a kind of legacy of colonialism. And I think that the second part of the question then of how does reparations contribute to kind of broader social justice, I think that's why you need a kind of more structural approach to reparations, so that not only is the prior harm being repaired or rectified, but that there's no repetition of that harm, you know, through kind of structures that you inherited from slavery and kind of colonialism. Yeah, so that's kind of in a nutshell. my initial thoughts.
That's a very nice nutshell.
Yeah, I think Melissa, you said it beautifully, and after slavery was abolished, after countries gained independence after post-colonial occupation, there was ostensibly equal rights in all of these societies, but the thing that has made equality difficult to overcome is structural inequality. And so I think we need to be thinking about reparations, but we also need to be thinking about the structure of the law, like Melissa said, and interrogate it basically everywhere. So paying reparations, but also changing the law and inquiring how the law maintains inequality over time.
Thank you. Yes, sir.
Sure, yeah, a couple of points that I would like the panel to address.
Could you identify yourself?
Cam Howard with the Global Circle for Reparations and Healing, and also Reparations United, both based out of the United States. Dr. Soomer talked about not being afraid of large numbers, and I think the numbers that she had was under 7 trillion for enslavement and 22 trillion for post-enslavement. UNESCO put the number actually at 777 trillion. So that's a huge difference, and I don't know how you arrive at that extreme difference. But the number is huge, much more larger than most people expect. The whole notion that we can't use law, international law, for historical crimes. That's what I'm kind of hearing. And I'm not sure I agree with that. And I'm not sure that, and I'm certain there's some other legal scholars who may have contention with that. Are you familiar with Professor Nora Bittman's book, Slavery, Reparations, Times Now, where she makes the argument that these are actually criminal rules that was, well, so-called rules among criminal engagement. These European states did not have the monopoly on law at the time. And certainly looking back in history, the crimes that they committed was never law legal. Going back to international law, like during the time of Egypt, and coming forward, the channelization of persons was never legal. And so we can't, and you did say we can't look at the Europeans' definition of law to be law, but there's the notion of ongoing impact, and which will allow us to utilize existing international law if we can prove, and we can prove the ongoing impact, as well as the immorality of the law that existed. If the law was immoral, how can it be law? And so we can still ways we can attack, or we can address historical crimes with the current international law that exists. So you can speak on that. But finally, yeah, I'll just leave it at those.
Thank you very much for your intervention. Any comments?
Yeah, I think I'm familiar with both of those, those arguments, and I endorse them, and I take them to be, correct reflection of the law, but also I think important tools that we need to use. I'm familiar with Dr. Nora's work, and I think that's kind of what I was thinking of when I said, we need to challenge the idea that, when we assess by whose standards, under customary law, when and by whom slavery and colonialism were declared lawful or unlawful. I was thinking of that particularly, the idea that if we look at the rest of the world and, the laws and the customs present outside of Europe, that we maybe would get a different picture of the legality of slavery, and particularly, I think, transatlantic chattel slavery. Because there's obviously something very qualitatively different about that form of slavery than the previous iterations. And then also the kind of the idea, the continuing harms of slavery and colonialism. I'm familiar with Judge Robinson's work on this, and it is an exception to the temporal principle that where you have ongoing harm, that this is not then barred by the intertemporal principle. And I think that there's certainly an argument to be made that, you know, much of the systemic and structural racism that we continue to face is not only kind of just a legacy of slavery and colonialism, but that it's actually a kind of continuation of the wrongful act. So yeah, I agree with you, and I think I'm maybe not saying that there's no way under international law to pursue reparations for slavery and colonialism, but I think I'm saying that we can find creative ways, but that even, you know, with those creative ways, there needs to be some kind of radical reformulation. These barriers can't be kind of held up as unassailable kind of opposition to reparation claims. So I take your point, and I agree.
Thank you very much. Okay. Lily, did you want to say Wania?
No.
Lily, is there any other question coming from? Okay, does anyone else in the room? Yes, please.
Yeah, Richards, Global African Congress UK, we're a reparations organisation formed in 2002. I'm hearing quite regularly now that you can't identify who the victims of enslavement were. And I just thought that's a pretty easy thing, because most of us ended up in the Caribbean islands or Brazil or places where people were taken. So why would it be hard to identify people as being?
Someone like to answer why is the question asked that it would be hard to identify the victims?
I agree with you. I don't think it's that hard to identify the victims, you know, and I think that we have, through recent jurisprudence at the ICC, more expansive ways of thinking about who can be included in that category of victims. So I think that, you know, the things that are going on right now to strike a hopeful chord can actually help us think more broadly about who the victims are, and how these harms endure over time. So I agree with you. I don't think it's that hard to identify.
Yes, please.
Hello, my name is Hendrickse. I'm looking for research fellow at the University of Oslo. My question is, I am not hearing a lot about the other slave trade, the Arabic slave trade. Is there a particular reason to not include it at all in all these discussions that we're having? Is there, or is it like, I don't know, put aside, marginalized is also a very important in terms of numbers and harm. So I'm curious if any of you has any answer in relation to this. I know I certainly haven't heard a lot about it at the forum in the past two sessions. Yeah, and I think we're missing quite an important bit of our story here as well. So, yeah. Sorry.
Can I clarify what you're saying for my own purpose?
Yes.
So when you're talking about the Arab slave trade, you're talking about the East African slave
Yes, the East African slave trade.
whereas Africa was depopulated on its East Coast as well as
Yes,
the West Coast.
as
So I just want to clarify that
Yes,
we're talking about
apologies.
African to.
Yes, thank you.
Can I just add something? Because there was a lot of colonization on the western side of the continent as well. So there was a lot of erasure of identity and so on. So that too has impacted the continent.
Zanzibar, Mozambique.
Yeah.
Yes, so I just want to make sure we're clear on what we're referring to. Is there any response? I want to think of why have we not included discussion of the East African slave trade, which lasted longer than the transatlantic, and there are estimates that there are 3 times more persons who were taken in East Africa.
I think maybe the Durban Declaration kind of said that's just the caloric magnitude of the transatlantic slave trade, the negation of the humanness of a person's being that took place in the duration, the cruelty of the transatlantic slave trade is why we may give more emphasis on it. But certainly, you know, all the West African countries where Islam is the leading religion as a result of the Arabic trade, the Arabic colonization process. And I think maybe a third of Africans are Muslims, you know, so that's the result. That's the only impact of that. So certainly it's something we should raise, but I think that it's largely because of the negation of the humanity of Black people in doing the transatlantic slave trade and the historical white superiority and Black inferiority that grew out of that. And that we all, that the whole world is grappling with, whether they're African or Asian or whatever. That process is affecting really the entire planet.
So a couple things. I think, just as Melissa said, and Cam, as you said, when we talk about international law, we should really call it European international law. That's what it is. And there are other kinds of law. And we're at a time now when if we're reinventing and we're rethinking and we're questioning European international law, we have to bring other kinds of law into the fray. And we have to think about how it matters now as a matter of law and as a matter of reparations, whether slavery was illegal or not. And I think that is a really big open question in the law. And I think we need more scholarship on this question. We need more and different examples. And so I don't know about this topic very much, but I think there's a lot of room to bring it into the forum. And I think the forum gives us the opportunity to shape the conversation and also to inform, to bring in other examples. And so I think it's great that you're studying this and that you're looking into this, and maybe it can help us refine and reform and question the legality of slavery over time and what that means in ways that help us all get past it and deal with its legacy.
Would you like to say something on the issue then?
No.
Let me conclude with, I think that one of the things that is wonderful is when we grow out of our own ignorance, even about the harms and slave trades of others. And the largest slave revolt in the world happened with the Janzi in 869. It's the East African trade of slaves in Taiwan. So I think that's something that we can start feeding and enriching ourselves with, to understand the breadth of slave trading and the breadth of the depopulation of Africa due to enslavement. Well, with that, I'm just going to ask each panelist if you have a closing remark.
It's very fine. I feel fine.
You feel fine, you feel fine.
No, it's very challenging to think about this, even about the question you put. And I think for the 21st century, the question is also question the origin of the capitalism. You know, we are talking about this amazing. We cannot talk about the reparation. We are talking about the reparation in front of such kind of system that was largely nutrido, largely fed by the for the slavery at the modern age. This is the point. Cheap, colonially, change the world. And not change the world. We know what's happened in America, in South America. We know what's going on, what's happening with indigenous people in Brazil. So we talk about a very special moment of your humanity. One part of this humanity, it was destroyed. Simple like that. Simple like that. In the case of Brazil, South America, but in the case of Brazil, we know now more than a few years ago what happened with indigenous people. You know, when you're still facing the result, and probably now we are more conscious about what it means. But we don't still try to figure out how many language was destroyed, how many people are dying, which kind of secret you are just not rescue anymore. We don't know what's this hell. You know, the idea to take people from one country and sell them to another one.
I'm going to let other people have their closing statement. Melissa or Britta?
Maybe just to counter some of the depressingness of my intervention. I think, I mean, despite my own, really critical views on international law, I think that there's a lot of reason for optimism. For a long time, the Durban Declaration, which was, more than 20 years ago, was one of the only international instruments, and it had been marginalized. It was a declaration that nobody wanted, well, nobody being Western states wanted to really acknowledge and grapple with. It had been the only kind of international instrument that really recognized the legacy of slavery, colonialism, the impact on kind of contemporary human rights and systemic racism. But we've now seen in the last 2-3 years a proliferation of reports by different UN mechanisms. I mean, the Permanent Forum is here and is speaking about, the question of reparations for slavery and colonialism. It shows that the pressure of movements, over the last 20 years that have been working on the question of reparations is now kind of culminated in forcing the UN system to confront these issues. And I think that that's, something really to be celebrated and a cause for optimism. And I see the kind of the fruits of people's work over the last kind of decade or more. And I think that's something to really be hopeful about.
I want to echo that. I don't want to end on doom and gloom, and I didn't mean to sound too gloomy. I think that international law is a bricolage. It's something that people made by finding whatever was at hand, from domestic law, from whatever they were familiar with, and they made it. And so just as they made it in a bad way, I think we can use the same kind of bricolage, creative thinking, new arguments to remake it. And so that's a process that requires a lot of time and a lot of scholarship, but I think there are more people than ever who are questioning it and who are engaging with it in a deeply critical way. And so I think we are going in the right direction, and there's plenty of room for creative ideas.
Thank you. So I'd like to take this time to thank everyone, and particularly those who are present in the room and those who are present online, for your patience. But very much, I'd like to thank the panelists. Dulce, if you're still there, thank you very much. But Wania, Britta, and Melissa, you have really given us, I almost want to say hope.
Yes, we need it.
Yes, we need it. I think we're going to grab one. So thank you very much.